Good morning, everybody, and thank you for joining us for our Summer Employment and Immigration webinar. I use the word summer loosely looking out the window, but here we are. My name's Devin Kagram. I'll be chairing today's session. Before we begin, a few housekeeping points. All your microphones and cameras have been switched off, but we do have a Q&A function, so if you want to ask any questions, there'll be time for questions at the end. Please put them in the Q&A chat throughout, and please do put your name next to the questions. The webinar will be around an hour, including the questions, and will be recorded. As I mentioned, questions, please do use the Q&A tab, and there will be some poll questions throughout, so please do participate. Your answers are anonymous, but it helps us get an idea of the questions we're asking on those topics. So today we've got a pretty packed schedule. We're talking, firstly, Anna and Artie will be talking about employees returning to the office and employee monitoring and the issues and legalities around that. It's becoming increasingly a challenge for employers. Elliot and Matt will be talking about recent changes to the immigration system in the UK and compliance. And then Charlotte and Emma will be talking about recent updates in employment law, including in relation to holiday pay and the hire and refire policy. And as we're on the eve of a general election, Charlotte will be also giving us a rundown of the manifesto pledges of the key parties. So I'm going to hand over to Anna now. Over to you, Anna.
Thank you, Dev. So I want to start today by talking about what I've termed the big push back to the office, because certainly in terms of the queries which we're seeing in the past 12 to 18 months, a common theme has been employers trying to encourage employees back into the office. Let's get my slide started, sorry. There we go. So can I start by conducting a little poll, just to get a feel in the room as to what you're all doing. So it's multiple choice, should pop up on the screen now. Poll question. Aha, there we go. So what is your office work policy for employees? Sorry, there's quite a few choices because there's a myriad of different options that we're seeing. So the last one is if you allow different, you have different policies depending on the type of role, just to clarify what we mean by that. So just a few seconds to respond. Interesting. So 71%, that's pretty big, asking for 3 days in the office. No fully remote or fully flexible. Okay. And 1 to 2 days is pretty popular. Okay, that's consistent with what I've seen in terms of what my clients are doing. So there has been increasing tension, I think, in the past year or so, because a lot of employers are rowing back from what was quite a generous hybrid working policy theme that we were seeing. Lots of the banks, the likes of JP Morgan, have been asking people to come back in 5 days a week, and they've operated a bit of a stick approach in terms of imposing disciplinary or corrective action for those people who don't comply. Their CEO described home working as an aberration, but we're also seeing the likes of Boots asking people to come back in full-time as of September this year. Other businesses are trying to incentivize a return. So sometimes bonus schemes, for example, or even base pay varies depending on how often people are prepared to come into the office. And certainly that's something that we've seen in the legal sector, as well as some soft benefits. So offering yoga classes and those types of things to try and encourage people to come back in. Now, interestingly, there hasn't been a huge amount of case law on the topic. And part of the reason for that is because there tends to be a time lag between what we see on the ground as practitioners and the time it takes for cases to be listed in tribunal and for judgments to be published. But we have had quite an important case in the Employment Tribunal, which was published last year. And I want to talk to you about it because I think it's quite helpful to employers who are struggling with those employees who don't want to come back in. And that's the case of Wilson and the FCA. My slides are really not playing ball. There we go. So Wilson was a senior employee. She'd worked with the FCA for quite a long time. She'd risen through the ranks and she had managerial responsibilities, 5 direct reports, and she was indirectly managing, I think, a further 10 members of staff. Never any suggestion that she was underperforming. She'd always been exemplary, but she had worked remotely in the same way as the rest of us during COVID and in a period following COVID. And she'd done so very well. There was no suggestion that her performance had dropped off in any way. Her appraisals had been good. But the FCA decided that it wanted to put in place a hybrid working policy with a 40-60 office-home split. And she said she couldn't comply with that. And she put in a formal flexible working request, which would have meant a formal variation to her employment terms, contractually permitting her to work from home. Now, when looking at these types of requests, the point I really want to hammer home is that it's a mistake to have a blanket or generalized policy and not look at the individual requirements of the role and the specific job in question, because that is what the tribunal will expect you to do. So in relation to Wilson, it was relevant that she had managerial responsibilities. She had team meetings with other senior managers once a week, which were in the office. She was expected to attend training sessions in the office, have one-to-ones with those people she managed, and have meetings with stakeholders. And the FCA said that they thought her performance would be compromised if she wasn't having face-to-face interaction during those sessions. And the reason I want to talk a bit more about the case is because the judge has articulated very well why working from home and attendance on team meetings is not a substitute for face-to-face interaction. And it can be quite difficult, as you know, to articulate exactly why there is a difference between the two. So she said in the judgment, the fast-paced interplay of exchanges which occur in planning meetings or training events when rapid discussion can occur are much more successful than in situations where people are working from home. And she talked about how people observe and respond to non-verbal communication in a different way. And that often arises outside of the context of formal events, but nonetheless forms a very important part of how people work and interact with each other. And that's particularly the case when looking at people in senior positions. And that, I think, is the nub of it. It's this concept of spontaneous discussions, innovative solutions, decisions being reached more quickly when we're not relying on 2, 3, 4 scheduled conversations on Teams. And I always give the analogy of my training as a junior associate and a trainee solicitor. It's the concept of learning by osmosis. So I sat in a room with a senior partner, and a lot of what I learned, a lot of my training, was not so much from the meetings which I was invited to join, but from listening to her conversations, earwigging, picking up on her working styles, and that concept of learning by osmosis, which is lost, I think, when people are at home working in isolation. And I suppose, turning it on its head, the other side of the coin is the mentoring piece. If you don't have visibility in terms of what somebody's doing on a day-to-day basis, I think some of the training and supervisory element is inevitably lost. Hopefully that's useful to you if you're faced with these types of letters, if you're asked to draft a decision, because as I say, it can be quite hard to explain why there is a difference, particularly when people worked pretty well during what was an emergency, unprecedented situation in COVID. Other things to mention, I suppose, are mental and physical well-being. So the scientific data suggests that when people are at home and they're isolated, there might be feelings of loneliness. They lose that collegiate feeling, that team bonding, which might otherwise arise if they're with colleagues on a day-to-day basis. And there's physical well-being to consider, not just in terms of people taking insufficient breaks, but losing out on the commute and those types of things. So things to think about if you are asked to draft a letter of this type or consider a request of the type that was considered in Wilson. Just want to return now to the contractual position, because a question that we're often asked is whether or not the employer has the contractual right to enforce somebody's return to the office when invariably a hybrid working policy or remote working policy was introduced as a result of COVID. How does that interplay with the contract of employment? Well, the contract of employment might seem obvious, has to be the most important document. That's your statement 1, terms and conditions. And the relevant clause will obviously be the place of work clause. And 9 times out of 10, that will refer to the office address as the place of work, because most employers didn't change the contracts. So that's helpful because express terms take precedence from a contractual point of view. How does that relate to the hybrid working policy? Well, usually 9 times out of 10, the policy should be non-contractual. And the best policies will say that they are subject to change from time to time, depending on business need. And if you can articulate to your workforce why the business needs have changed and why you now need people back in, perhaps because there's been a drop-off in productivity, perhaps because there's been negative feedback from clients, whatever it might be, then you should be in a good position to explain to employees why there needs to be a change to that policy. You can, of course, refer to your express contractual rights in the contract, assuming that that refers to the office. And for those people who don't comply, then it's open to you to take remedial action. I would suggest starting with an informal discussion, but you may, in extreme cases, need to bring disciplinary action for failure to comply with the contract and the change to the policy or procedure. What you have to be mindful of is ensuring that you're monitoring adherence to that change in the policy. So if you have somebody who's just ignoring you and remaining at home, you do need to follow up with that person, because over time, they may assume an implied right to work from home as a matter of custom and practice, and you may be seen to have waived your contractual right by not taking any remedial action. So do monitor whether or not people are adhering, and that's where Artie's piece will come in, and she'll talk to you in just a moment. For those employees who are not happy with the change in policy, again, it's open to them to make a flexible working request, and the outcome will be, if the request is successful, a change to their terms, a formal variation to their contract. I don't intend to go through the requirements for flexible working, which you'll all be familiar with, but it's the direction of travel seems to be that it's getting easier and easier for people to make a request. That's a right to request. It's not a right to work from home or to work flexibly, but it's a day one right now. It doesn't have to relate to childcare or carer responsibilities. Yes, you need to tick the boxes in terms of the procedural requirements, but the absolute key point to be aware of is whether or not the employee has any Equality Act rights which come into play. So invariably it will be an employee returning from maternity leave, and the argument they might raise is that if you don't agree to the request, you are operating a policy which indirectly discriminates against women. Or you might have a disabled employee, for example, who requests to work from home to accommodate a disability, and that's where you have to be particularly careful. And without getting bogged down in the different legal tests, the key thing to remember is that you are looking at a balancing act between the needs of the business and the needs of the individual, and you need, as far as possible, to have tangible evidence and a good explanation as to why the job cannot be done from home. And that's why it's really important to keep records as to why, or evidence as to why you think that home working compromises the performance levels of the business and the individual. Some cases here just as health warnings as to where it can go wrong if you don't pay heed to the Equality Act. Don't intend to go through those, but certainly these are the types of cases that we've seen come through in addition to the Wilson case, which I mentioned earlier. So just to sum up, just some key takeaways really. Don't always assume that office working is the best way of working. It tends to be the case that balance between the two is more likely to get buy-in and may be the best thing for you as a business. Do think about the impact on recruitment and retention, because certainly we've seen that where offices are particularly strict or companies are particularly strict, that's affected how easy it is to recruit and also retention of talent. For those people where you're not quite sure whether or not their flexible working request will be successful, do consider a trial period, because that will give you an opportunity to gather evidence as to why you don't think it's working, which will put you in a much better position to defend any claim. And of course, it's a genuine opportunity to test it if you're not sure. And the key point has to be being careful not to discriminate. So the Equality Act provisions and ensuring that you always pay heed to protected characteristics to the extent they're relevant to any flexible working request. Okay, so Artie, I'm going to hand over to you so you can talk a little bit about employee monitoring, particularly in the context of the data protection legislation.
Thanks, Anna. Morning, everyone. So yeah, just following on from Anna's segment there, it's becoming very common now that we're seeing that employers are requiring employees to attend the office more, and there's kind of a bigger push towards hybrid working. And in doing that, employers obviously want to make sure that employees are adhering to any policies in relation to hybrid working, but also that they're able to monitor that if employees are working at home, they are still productive and they are working as required. And that's where employee monitoring has come in. And there is obviously a lot of discussion around employee monitoring at the moment. There are various types of, oh, sorry, I just realized I forgot to change the slides. Let me just change those. There we go. Sorry about that. So there are various methods of surveillance, such as using CCTV, video surveillance, or monitoring device activity in the office or even at home. But there are differing levels and extents to which such activity can be carried out and to which extent it's lawful. And the issue of employee monitoring has been looked at quite widely, and there's a lot of guidance coming out about when monitoring is okay, when it's a bit, when it might present more difficulties for an employer. So in 2023, there was some guidance that came out. The Institute for Public Policy Research put out some guidance suggesting that keystroke monitoring, which, for example, is one particular type of monitoring that is likely to be limited in its enforceability or legitimacy, that actually it should be banned. And also the Information Commissioner's Office, the ICO, also published some guidance, which was the purpose of which was to assist employers with complying with their obligations in relation to their data protection. So obviously data protection law doesn't prevent employers from monitoring workers, but it has to be done in a way that is lawful and fair, especially in relation to, notifying employees and also the extent of how far the monitoring goes. So there are certain considerations that need to be followed when deciding what kind of monitoring to impose on employees. And some of them are set out on the screen in front of you. But to summarize, one, the most important is to identify a legitimate purpose for the collection of the personal data. For example, in circumstances where employees are asked to return to the office, the legitimate purpose would be to monitor and assess employees' adherence to any hybrid working policy. It's also very important to ensure that the data is collected only collected to the extent that is necessary and proportionate to fulfill that legitimate purpose. And also it should not be stored for any longer than is necessary to achieve that. It's also very important that employees are informed that they're being monitored, because that's, I think, come up quite a few times where employees might see it in a policy, but they're not actually aware of the extent to which they're subject to monitoring. And this could be achieved by including a paragraph in a hybrid working policy that explains the importance of in-person attendance and what's monitoring they may be subject to. But again, it's important that employees are made aware of this, and it's not just sitting on the intranet where they might not actually see it. So a couple of interesting examples of miscompliance that's been in the headlines over the past few years. The first one is Barclays Bank. So in 2020, Barclays began to monitor their employees' productivity by using a software program that monitored the length of time that employees were away from their desks. And there are a couple of issues with this. The first is the fact that Barclays didn't actually inform their employees that they were subject to this monitoring. And secondly, which would have been a serious infringement of their privacy. But it was also pretty extreme in the sense that monitoring how far they stepped, how often they stepped away from their desks for loo breaks or cigarette breaks or tea breaks. That was pretty excessive and extreme in terms of what the monitoring was there to achieve. Following on from a backlash from staff, the bank then decided they were only going to gather anonymous data rather than individual data. And obviously, anonymous data then avoids the issue of personal data and data protection. Nonetheless, the ICO did still investigate Barclays for this. However, no further action was taken on the basis that, they steered away from a personal data breach. But the interesting thing is that had the ICO found breaches, had Barclays not resorted to gathering only anonymous data, they could have been fined a maximum of 4% of their global annual turnover, which would have been £865 million. So I think they were quite lucky in that respect. Another interesting example is in relation to Amazon France Logistique. Now, Amazon, this is one of Amazon's large French distribution centres, and AFL are responsible for managing those centres in France. And in this scenario, the employees in these warehouses were required to use individual scanners, and the scanners both collected data on how quickly the items were scanned and how much downtime there was between scans. So essentially, it did monitor productivity as well as monitoring, the actual products that were passing through their hands. And the scanners then enabled AFL to report potential or actual errors by employees, but also productivity, and that played into how they then dealt with their employees. AFL then stored that data for 31 days and used it to plan work schedules, assess performance, and identify training needs. So it wasn't just used for the purposes of, parcels. And AFL also deployed video surveillance at certain warehouses. So in November 2019, CNIL, which is the French Data Protection Authority, commenced an investigation following media reports on the practices that AFL was following. And in July of 2023, CNIL found that AFL had committed a number of serious breaches of GDPR, including those related to what you see on the screen, which is essentially, having data for too long, not having a lawful basis for gathering this personal data, and not providing the information to those that were being monitored to notify them that they were in fact subject to this quite serious monitoring. And in December 2023, they were issued with a fine of 32 million euros. So the CNIL's decision is not actually binding on the UK, but it does raise some really important issues for UK businesses. The ICO report that I mentioned earlier that was in 2023, that did actually have some very similar kind of obligations and guidance in relation to employee monitoring, as was raised in the CNIL judgment. So obviously there is quite a lot of crossover between the two, and I guess the principles are very similar. One interesting thing that the ICO's guidance noted was that 70% of those that participated in the survey said that they would find monitoring in the workplace intrusive, and fewer than 1 in 5 people would feel comfortable taking a new job if they knew that their employer would be monitoring them. So it just shows that it's very important to balance the rights and privacy and human rights of employees against the need for the employer to monitor those employees, because there is a risk that employees will push back if they find out that there's an excessive level of monitoring happening in the workplace. So I think one of the key takeaways is that whilst businesses may have a legitimate business interest to protect, through monitoring. It can't be excessive, and it can't be disproportionately impacting the human rights of those that are being monitored. And essentially, the more intrusive the monitoring, the stronger the business need has to be, or the business interest has to be, to justify that monitoring. The CNIL also found that temporary workers hadn't been properly informed of the monitoring processes, and that the intranet was not sufficient in notifying them of this. And this is actually very similar to something that the ICO is currently consulting on, in terms of the steps that employers have to take to bring privacy policies to the attention of employees. And therefore, as a belts and braces approach, it's likely to be insufficient simply to refer an employee to the intranet and say, please see X policy on the intranet in relation to monitoring. What is probably a safer approach is to provide employees with the policy, ask them to confirm it's been read, ask them to sign it, or confirm via email tick box that it's been read. And this just protects the employer from an argument that it wasn't clear and an employee hadn't agreed or consented to such monitoring. Of course, in practice, this might not be realistic. Obviously, getting employees to sign these policies isn't always possible. So it is a bit of a balancing exercise here in deciding whether or not it's realistic to do so and the risks of not doing so. So just by way of a summary, it is possible and it is permitted under data protection legislation for employers to monitor employees. However, there is no fixed answer as to what is acceptable and what isn't, as is always the case. It will depend on the facts, but the key point is that any decision to monitor has to be considered and thought out, has to be justified on the basis of the data protection principles, and it has to be balanced and proportionate to ensure that employees are not disproportionately disadvantaged by such monitoring. So that brings me to the end of my slides. I will now hand you over to Elliot, who's going to provide an update on the immigration regime. Elliot.
Thank you, Arti. Thank you. I feel like every time I talk at one of these things, it's to highlight some kind of Home Office horror. And the crux of today's talk really deals with the most recent set of major changes to the UK immigration system for several years. So since the introduction of the points-based system in 2008, UK immigration has really undergone a series of successive reforms, some of them to relax the rules, many of them intended to tighten restrictions, and really fundamentally to make immigration to the UK more difficult. And the changes that we saw introduced on the 4th of April this year really did the latter. There are wide-reaching reforms to salary and occupational requirements that I'll go on to talk about, and that's really left a lot of sponsors of non-UK workers facing a costly choice. So primary amongst these changes are the increases to the minimum gross salary threshold for skilled workers and for global business mobility workers. And we'll look firstly at the context of that. So the skilled workers are your new hires coming into a UK business, recruited to fill a genuine vacancy within the UK, while your global business mobility workers are effectively intercompany transferees. So they're existing employees who, as a sponsor, you would be bringing to the UK for a temporary period to complete an assignment for the group. Now, skilled workers are subject to a minimum gross annual salary threshold, and that increased by almost 50% in April, now sitting at 38,700, which is a fairly astronomical jump that immediately just carves out a lot of junior and kind of middle management occupations where, the typical kind of salaries would be below that level. The minimum rates for new entrants, so that's people who are under the age of 26 or for student graduates, has also increased in line with the latest ONS data. GBM workers are less affected, but still have faced a 6% increase in their salary, meaning that their qualifying threshold is now closer to 50,000. So the takeaway from that across both of those categories is that in order to qualify, new visa applicants under those routes would need to be paid either at or above that salary. Now, there are some concessions that you can benefit from, excuse me, such as discounted rates and transitional thresholds for certain occupations and certain visa holders, for example, people who are extending their stay in the UK. But they can be complex in their own right, and in many cases, applicants would still be subject to a fairly significant salary hike anyway. The second of the salary-based qualifying criteria is the going rate for the sponsored occupation. And both of the employment visa routes I've mentioned have got a minimum salary rate for each specific role that you can sponsor, meaning that a visa applicant has to be paid the higher of those two rates. Now, the government's latest changes have thrown those up too. And as with that base rate that I mentioned, the going rate has been perhaps unrealistically uplifted in some cases. I mean, to give an example, software engineers who you would sponsor under an occupational code for programmers and software development professionals, that's seen a 45% salary jump. Particularly badly hit are occupations in the maritime industry too, and some of our clients deem some of those increases just unviable, as it really kind of contradicts industry standards. Turning to something that some of you may recall, and that's the shortage occupation list for jobs in an industry that is deemed to be facing a skills shortage. So historically, that's been architects, software development occupations, geophysicists and the like. And those occupations were subject to significant discounts on their going rate under that shortage occupation list. In these 4th of April changes, the government has binned that list entirely, and what they've done is published a condensed immigration salary list, which has a reduced salary threshold. So the rationale is that rather than offering a discounted rate for all occupations that experience a labour shortage, that salary discount will apply only to the occupations that the government actually feels it's sensible to offer that reduced rate to. So on that basis, it isn't a like-for-like replacement for the shortage occupation list, and it certainly doesn't have the flexibility of its predecessor. And a lot of the occupations that previously were on the shortage list are not on the immigration salary list. Beyond the sort of salary-based issues, the type of occupation that you can sponsor have been altered as well. Some jobs have been removed from the SOC codes entirely and can no longer be sponsored at all, albeit there are some certain exemptions where sponsored workers are extending their leave with the same sponsor and they're performing the same role that they were sponsored to do. Excuse me. For some businesses, the takeaway for that is that the occupations that they've routinely hired for many years, such as architects, for example, would no longer qualify. Sorry, not architects, some sort of lower level roles, some of them in architecture, some in software, across industries. And irrespective of their speciality, or even their experience in that particular role, they wouldn't qualify for the visa. At the risk of sounding a bit like a broken record, the government also have upped the immigration fees in some areas. They have hiked the immigration health surcharge to around a 50% uplift, and that's hit applicants particularly hard. I'm not going to dwell on the figures, but you'll see on the slide I've presented an example setting out the cost differential for a visa of a duration between 1 and 5 years, and that just shows how rapidly those various mandatory fees ramp up. This example is for a standard occupation, so no discounts applied, sponsored by a small company and minus an independent. So if you factor in some of those changes, things like a larger company plus dependents, those costs just absolutely increase exponentially to quite a shocking degree. So what can you do as a sponsor to mitigate against all of those changes? I mean, I think first and foremost, factoring the immigration costs into a recruitment strategy first and foremost is important. Budgeting for that is key. I think auditing your existing workforce to really determine who of your sponsored workers will be subject to a salary increase when they come to extend their visa is important, and then determining whether that has an impact on you, how you'll have to deal with that. That's another thing that you can do. I mean, ultimately, if all else fails, there are alternative immigration routes that you can look at, albeit these are limited and are generally based around personal immigration circumstances rather than being employment visa routes. So things like thinking laterally, things like the family route, so dependents, if somebody has a partner who's British, for example, or the ancestry route for Commonwealth nationals, that could be a way of getting around the stringent new rules. And that really just requires a bit of thought and some discussions early on in the visa application process to make sure that you as the sponsor of a non-UK national have really considered all of the different options. So aside from these changes, and actually with something slightly more positive, and moving away from the sphere of the points-based system, the government introduced some wider reaching reforms recently that have impacted travellers to the UK. And from autumn of last year, they've introduced an electronic travel authorization, or ETA scheme, which allows individuals from certain countries, initially in the Middle East, to apply for an electronic visa, which would facilitate their travel to the UK as a visitor. So it can be used by individuals from those several nations who are coming to the UK as tourists or for business or for short-term study. And it's a low-cost sort of de facto visa replacement scheme. So where those individuals maybe had to apply for a visit visa from, you know, their local visa application centre previously, they can now do a digitized application. I think it costs around £10, and what it does is it gives them an immigration status that allows them to come to the UK for multiple trips across a 2-year period, or until their passport expires, whichever of those two is shorter. An obvious benefit of that, you know, is the term of the ETA scheme, and you know, the low cost alternative. And I think, you know, we're expecting to see that rolled out across other jurisdictions in future, to the benefit of travellers to the UK. Obviously, it doesn't get around employment restrictions. It's still very much tied to the visit visa regime. So, you know, you're talking about business visitors predominantly, and tourists, you know, people coming in for holidays or for business meetings, training, conferences, that sort of thing, rather than anything more involved. But still something to bear in mind when you're considering travel from those countries. Thanks for listening to that whistle-stop tour through the recent changes. I'm now going to hand over to my colleague Matt, who's going to discuss the latest immigration compliance updates and some of the right to work restrictions. Thank you.
Thanks, Elliot. Morning, everyone. Yeah, from my side, I will be focusing more on the immigration compliance elements, as Elliot said, both under the main work routes and also just changes and pointers for UK-based employers in general. There have been some changes both legislatively and logistically that have occurred this year, so it is important to be aware of these. To start off with, a quick question from my side regarding the very glamorous world of right-to-work checks. Not to dwell too long on it, but online IDVT and government UK platforms have now been in place for some time, so it would be good to understand whether you and your teams are currently utilising these or maintaining a more manual model for the process of doing right-to-work checks. So if you guys just want to take a quick look at the poll, make an answer, and then we can have a look and see. Okay, interesting even split there. So there are some changes that need to be noted. A predominant one is this, is that there will be a move to an entirely electronic visa system by the end of 2024. So visa holders who currently hold a biometric residence permit card are currently being contacted on an individual basis to transfer their visa to an online status. And eventually all UK visas will be issued on that online platform. So right to work check guidance isn't formally changing as a result of this, but it is a good prompt to review right to work checks that you have on file for existing employees, specifically for visa nationals, in addition to processes being undertaken by HR professionals or employer representatives doing the checks. Since the start of the pandemic, there have been multiple changes to right to work check guidance, and what was accepted as due process several years ago, like taking a copy of the front and back of a BRP card, now doesn't apply in many scenarios. So visa nationals are mandated to use the government's online service. It is also important to remember that any checks that have been carried out incorrectly ultimately aren't valid and don't constitute a statutory excuse against illegal working. The penalties for right to work check breaches trebled in January this year, and the Home Office now levies a fine of £45,000 per breach identified for first-time offending employers, which then increases thereafter, in addition to company naming and shaming on their website. So if multiple breaches are identified, then this can obviously amount up and become quite costly for employers for something that's ultimately easy to avoid. Moving on to changes more specifically for sponsors. In terms of visa sponsorship, the Home Office in recent years have been very vocal about the need to monitor compliance. They view the ability for companies to sponsor migrant workers as a privilege and not a right, and the amount of registered sponsor license holding companies has increased substantially since the conclusion of the Brexit transition period, which in turn increases the Home Office's requirement for employer monitoring. There's no current indication that this focus will shift, depending on the election result based on initial outlines in the main parties' manifestos. The Conservatives have predictably indicated in their manifesto that this approach should continue under their leadership, and Labour have also announced that they intend to increase the timeframe that an employer would be banned from obtaining a skilled worker sponsor licence if that employer has been found to be in breach of employment law. So sponsoring employers can expect to face continued scrutiny. A major change that occurred in April this year for sponsor license holders under the main work routes is that these licenses no longer need to be formally renewed. So previously a sponsor license would be valid for a period of 4 years, and then a renewal application would then have to be actively filed. Now all licenses will be valid effectively indefinitely, and only sponsor licenses which are deemed to have no activity will then be frozen centrally by the Home Office. So the positive side is that this change removes upfront admin burden on employers to actively submit renewal applications, but we may find that this becomes trickier from a compliance perspective. A renewal application was always a good prompt for an immigration audit, as effectively employers were putting themselves in view of the Home Office and acknowledging the need to keep sponsoring migrant workers. And it also served as a touch point for employers to review their documents and ensure that their houses were in order. This prompt has effectively now been removed. From the Home Office's perspective, it also removes the need for staff to monitor and review license renewal applications. So these staff should now be allocated to other projects, and there may be a drive for them to move across to the auditing space as they'll have experience of sponsor obligations and reviewing these. So with this in mind, we do expect site visits to potentially become more randomized in the future. It's also still important for sponsors to monitor any kind of substantial company change, as this may impact license obligations and still need to be reported in the normal way. So for example, if a sponsor grows from being a small business to a medium or large enterprise, then this still needs to be reported to the Home Office, as it can impact certain fees that need to be then paid on individual visa applications. So moving on to penalties for compliance breaches. So as the Home Office are putting more of a focus on sponsor compliance, it makes sense that they're also increasing enforcement where breaches are established. There are now quite frequent news stories about Home Office audits and crackdowns, and current statistics show a substantial uptick in enforcement over the last 2 years or so. For example, in the first quarter of 2024, 309 sponsor licenses have been suspended, with 210 of those licenses being revoked. This is up quite substantially. For reference, in the same period of 2023, the Home Office revoked 139 skilled worker sponsor licenses. So we're looking at an increase of about 50% over that year period. A lot of this currently is being targeted specifically at the care sector. The Home Office have that area in particular as being common for immigration law infringements. But the rise in enforcement numbers across the board do show that the Home Office are putting a wider target on all sponsors. So measures should be taken by employers to ensure that houses are in order in case of any particular audits or site visits. In addition, certain breaches don't have to come to light during a full compliance visit. It is now quite common for the Home Office to share data with other government agencies, most notably HMRC. For example, monthly company payroll data will usually be sent to HMRC, and this can include an employee's nationality information. This is frequently how the Home Office will suspect incorrect right to work information, and may contact employers to request further clarifications or copies of right to work checks. We are aware of cases where employers have had fines levied against them for right to work check breaches, either because they responded incorrectly to a Home Office request for information, or they just ignored it altogether. So UK immigration enforcement can be stealthier than the Home Office deciding to take a full on-site visit of an employer. And it just underlines how vital it is to ensure that all bases are covered, as these issues can impact both sponsors and non-sponsors alike. So on that cheery note, I will now hand over to Charlotte, who will talk about potential employment law changes as a result of the election.
Thank you, Matt, and good morning, everybody. Just move my slides along. So as many of you will know, various changes to employment law came into effect during April this year, many impacting on family-friendly rights. And a number of other proposed changes had been expected later this year or beyond. But following the calling of tomorrow's general election and the dissolution of Parliament at the end of May, most of the current government's draft employment legislation will no longer proceed, although some unfinished business was passed through the wash-up process. And I will cover this briefly as part of my section before taking a very quick look at the employment-related manifesto commitments made by the largest UK-wide political parties. So starting with changes to family-friendly rights that have already come into force this year. Amendments have been made to the paternity leave regulations and take effect in relation to children whose expected week of childbirth or their date of placement for adoption is on or after the 6th of April 2024. The amended regulations introduce certain key changes to the paternity leave regime, and just summarising the key points here. Firstly, leave can now be taken in 2 separate blocks of 1 week or 1 consecutive block of 2 weeks, rather than employees having to take just 2 weeks together or only 1 week. Leave can now be taken at any point within the first year following birth or placement for adoption, which is up from having to take the leave during the first 8 weeks. And there's also been shortened notice periods, so now only 28 days notice each period of leave is required, rather than employees having to give that notice 15 weeks before birth. We've also seen changes to redundancy protections. Now, with effect from the 6th of April this year, new regulations extended the existing redundancy protection in place to pregnant employees and those who have recently returned from maternity, shared parental leave or adoption leave. As many of you will know, employees on maternity leave, shared parental leave or adoption leave already had special protection when a redundancy situation arose during their leave period, having the right to be offered a suitable alternative vacancy if one is available before being made redundant in priority to anyone else at risk of redundancy. Now, I've set out the details of the extension of the protection on the side in front of you. I won't talk through that in any detail, but one sort of point that I just thought it was worth flagging, it's worth remembering that the protection only gives employees priority for redeployment opportunities. It's not a ban on making employees redundant during the protected period. Employees with priority status can still be selected for redundancy. The protection just kicks in when it comes to the allocation of alternative roles. And then just moving on to a type of statutory leave that came into force this year. The Carers Leave Regulations 2024 came into force on the 6th of April, and they create a new statutory right to unpaid carers leave. So an employee who has a dependent with a long-term care need may take up to 1 week's unpaid leave to provide or arrange care in each 12-month rolling period. Now, carers leave is a day one right, so employees don't have any minimum service requirement to be entitled to the leave. The leave can be taken on separate days. It doesn't have to be consecutive. The entitlement to 1 week's leave is the maximum any employee is entitled to, irrespective of how many dependents they have. There are certain notice requirements that employees have to comply with. Quite importantly, there is no requirement for employees to evidence their entitlement to the leave. And employers are not able to deny an employee's request for carers leave, but they can postpone the leave if it is reasonably considered that if the employee were to take the carers leave, that the operation of the business would be unduly disrupted if the leave was approved. So as I mentioned earlier, a number of proposed changes had been expected later this year and beyond. Following the calling of tomorrow's election, most of the current government's draft employment legislation will no longer proceed, although some bills were rushed through in the rush-up process. This includes, for example, the Paternity Leave Bereavement Act, which had provided that paternity leave will become a day one right for bereaved partners where the mother of a newborn or adopted child has died. Also, the statutory code on fire and rehire was rushed through, and Emma will be talking to you all about this next. And then there are also a number of employment law changes which were not progressed, which has left their status uncertain. I've given you a few examples of those. One that's perhaps worth noting is the limit on the length of non-compete covenants. So following a consultation, the government had announced earlier this year that it was going to legislate to limit non-compete clauses to 3 months post-termination of employment. And it's unknown whether a future Conservative-led government would act on this, and none of the other parties have indicated any intention to do so. So we'll have to see whether anything comes of that in the future. And then just to finish off, as we are on the eve of a general election, I thought it would be rather timely just to finish off by summarising a few of the key pledges of the main UK-wide political parties relating to employment law. So the Conservative Party, firstly, in addition to the current government's proposed changes that I've already flagged, the Conservative Party has outlined some further changes. For example, it's planned to overhaul the fit note system, to move responsibility from GPs to other healthcare professionals so that, quote, people are not signed off sick as default. The Labour Party pledges to implement its plan to make work pay, delivering a new deal for working people, and introduce legislation within 100 days, although they say that they will consult with businesses and unions before passing any legislation. Now, I think it's fair to say that their proposals are ambitious, and would certainly change areas of employment law as we know it quite significantly if implemented. And a couple of their key proposals, I think the most significant is the pledge to introduce day one protection against unfair dismissal, as well as other day one rights, sick pay and parental leave, for example. The party also said that it will make flexible working as a default right unless employers have a good reason to refuse it. And then the Liberal Democrats manifesto also proposes a number of changes to employment law and workers' rights, for example, including an increase to statutory maternity pay and shared parental pay to £350 per week. And the party is also proposing a shift to the burden of proof in employment tribunals regarding employment status from the individual to the employer. So that brings me to the end of my whistle-stop tour of recent and future changes to employment law. And I will now hand over to Emma, who is going to talk to you about the statutory code, fire and rehire, as well as recent changes to holiday pay.
Great, thanks, Charlotte. I'll just move the slides on there. Yes, so I will first speak about the new code of practice on dismissal and re-engagement, which is informally known as the code of practice on fire and rehire. So onto my first slide, and about the new code. So this new code largely came about because of all the controversy around 2 years ago when P&O Ferries dismissed 800 members of staff without consulting them. Some of you may remember the story in the news. The events at P&O raised lots of questions on the issue of fire and rehire, although in fact P&O didn't rehire the employees it dismissed, so it wasn't exactly a fire and rehire scenario, but nonetheless, this kind of terminology in the press, it all meant that there was this increased political support to legislate on the practice. And fast forwarding to recent months, on the 28th of May, Parliament approved the Code of Practice Order 2024 during the so-called wash-up period, so the period shortly before Parliament was dissolved ahead of the election tomorrow. And the code will come into force in England, Wales and Scotland in just over 2 weeks' time on the 18th of July. So taking a step back, why do employers fire and rehire employees? Well, people have different views. Some argue that the practice enables employers to remove favourable terms and conditions from employees' contracts, as well as to prevent negotiations with employees and trade unions about amendments to their contracts. Others are less cynical and think that fire and rehire can be a helpful tool in the absence of other options to protect the workforce, for example, by preventing mass redundancies. And this then brings us to the question of what the code does. The code sets out various actions that an employer should take, where one, it wants to make changes to employees' terms and conditions of employment, and two, it anticipates that if the employees and or their representatives do not agree to some or all of the contract changes, it might dismiss and re-engage the employees, or indeed engage others in their roles. The purpose of the code is on the slide there, and it's described as being to ensure that an employer takes all reasonable steps to explore alternatives to dismissal and engages in meaningful consultation with a view to reaching an agreed outcome with employees and or their representatives. The code says that employers should consult with employees for as long as reasonably possible in good faith. And it says that employers should contact ACAS, so the Advisory, Conciliation and Arbitration Service, which I'm sure many of you are familiar with, for advice before raising the prospect of fire and rehire. The code applies irrespective of how many employees are affected or potentially affected by the employer's proposals. And if employers unreasonably do not follow the new code, employment tribunals can increase the compensation awarded to employees by up to 25% if they bring a valid claim, such as a claim for unfair dismissal. And tribunals may also reduce compensation by up to 25% if the employee has unreasonably failed to follow the code. That said, some will argue that the code doesn't incentivise employers to avoid fire and rehire, and this really segues into the general election, as Labour says in its manifesto that it plans to end fire and rehire. Whether it would strengthen the new code of practice or seek to outlaw it completely remains to be seen. And I will now finally touch on changes to the way that employers should calculate holiday pay, so very much moving away from fire and rehire. On the 1st of January this year, some new regulations came into force. You can see them named there on the slide. The regulations changed the way that employers can calculate holiday pay for part-year workers and irregular hours workers. Part-year workers include those who work term time. Irregular hours workers include those whose hours are wholly or mostly variable. So those who just work overtime occasionally shouldn't be affected by the changes. And employers will have two options for paying holiday pay to such workers for leave years starting on or after the 1st of April. So they can choose to roll up holiday pay and to pay it at the rate of 12.07% of the hours worked in a pay period. But note that this is where the employee is only entitled to statutory holiday. And if they are entitled to more than 28 days holiday in a year, so above the statutory minimum, the employer needs to use a different percentage multiplier. But that's a relatively straightforward calculation, and helpfully the Department for Business and Trade has published guidance on calculating it. And then there's the other option there, option 2 on the slide, if employers don't want to use the 12.07% calculation, and employers can pay holiday pay by taking the employee's pay for the 52 weeks preceding the calculation date, divided by 52 to work out a week's pay. There are some other changes to holiday pay that I don't have time to go into, but the one I just mentioned is the main one. And with an eye on the time, I'll now pass back to Devon. Thank you.
Thank you, Emma, and thank you to all the presenters today. There's a lot of interesting things that have happened and changes, and I think, you know, if the polls are correct and we do have a Labour government, I expect to see a lot of activity in the next few months on employment law, because certainly they will be looking quite closely at various employment law changes. So it's a case of watch this space, and we'll have to see how that develops over the coming weeks. We have hit the hour, but we are happy to stay on for a little bit longer to answer a few of the questions that you've provided. So we'll just, for those of you who can stay, please do. Those of you who drop off, just a couple of points to note. You will get a feedback form. Please do complete that. And that will also, as a little incentive, you'll get the slides once you do that. And those of you who dialed in, please do let us know if you attended by emailing the events email address that was on your invitation to let us know that you attended. And that's for people who dialed in by phone. Okay, so we have had a question first question is for Anna here. So for flexible working requests, we have a blanket policy that if we are accepting applicants go on a trial period for 3 months, is there any pitfalls or employment legislation we need to watch out for with this?
Well, I would say it's a very good thing actually to have a trial period for the reasons I described, because then if you're monitoring it properly, and I think that has to be the key point, you should at the end of the trial either have tangible evidence which you can use to demonstrate why it's an issue, or on the other side of the coin, it's hopefully worked out and you can feel more comfortable. In terms of pitfalls, remember that under the legislation, the whole process is supposed to be concluded within 2 months. So you need to be watertight with your documentation so that you've agreed with the employee and the employee has countersigned to that effect that the process will be extended to allow for a trial. So do be conscious of that, and be very clear in your wording that it is a temporary trial, and that if it doesn't work out, the employee will revert to their original terms. So there's no misunderstanding on that. A practical point is just keeping an eye on it, because what tends to happen is that everyone forgets about the trial. Nobody keeps an eye on it. Nobody has regular check-ins with the employee, and then nothing's done at the end of the period. So it's about diarising and keeping on top of it. I would also say that I think 3 months, depending on the role, could be a little bit on the short side, because really you might not get enough opportunity in that period, particularly if there's annual leave, for example, to properly test it. Now that will be dependent on the role, but do think about what the employee is doing over the course of a year. So if I give the example of corporate lawyer in our firm, they tend to be busy in the run-up to Christmas, between September and Christmas, on transactions. Now, if they've got a 3-month trial that only applies from, say, January to March, that's not going to give the employer an opportunity to properly test them and test the arrangement. So think about the period and what's appropriate vis-a-vis the job type. And I would say 6 months is more common. And it might be that you agree a longer period than that. And you may also want to reserve the right to extend the trial. So they're the things I think you need to be conscious of.
Thank you, Anna. So we've had a question for Matt. If we've carried out a right to work check on a visa holder's BRP card, do we need to recheck a visa holder's immigration status once they've transferred to the online system?
It would ultimately depend in terms of how the initial check was carried out. So formally, for anyone who has a BRP card, what they should be directed to do is use the government's online right to work check service. They then generate a share code, send that back to the employer validates their right to work. If that has been done, and that's been done correctly, then there's no need to redo this once the individual transfers their own personal status across. But this refers to what I was mentioning earlier. It's a good chance to check what right to work was done for that person. And if it's the case where you've only got the front and back of a BRP card, it's possible that that check wasn't done correctly in the first place. And now's the chance to rectify it using the online service. But you don't even need to wait for the individual to get the prompt from the Home Office to move to the online status. You can do that now.
Great. Thanks, Matt. Artie, there's a question for you. So can an employer use its VPN to track whether employees are working from home or the office in order to monitor office attendance?
So I'm not aware of any specific examples of where VPN has necessarily been an issue, but I guess it would just boil down to the same points that I mentioned in my section, which is essentially that there isn't, I'm not aware of a specific reason why it's not possible to use a VPN to monitor employees' attendance and where they're working, but it would have to be in line with the data protection principles and considerations that were mentioned. So, for example, you'd have to take into account all the legal considerations when deciding whether or not it's appropriate to do that. Yeah, I think that's the main thing. There's no kind of set answer as far as I'm aware, but it's more balancing the rights of the employees that are being monitored, making sure that if you do decide to go down that path, it's very clearly mentioned in policies. Employees are clearly aware that it's happening, because this is one that if an employee is being monitored in this way without being aware, it could trigger some serious consequences from the ICO, you know, off the back of the kind of the examples I gave in my section with Barclays and Amazon. So I think, yeah, it's more a case of, you know, check to make sure that on balance it's appropriate to use the VPN and make sure that employees are fully aware of the use of this kind of monitoring.
Thank you, Artie. And Charlotte, there's a question for you. How can you postpone carers leave? Obviously, you spoke about those changes.
Yeah, so as mentioned, employers can postpone a request if they reasonably consider that the operation of the business would be duly disrupted. And currently, there's no guidance on exactly what might amount to undue disruption. But I think it's quite likely to include a scenario where you know, within the business, you've got nobody that could cover the particular employee that wants to take leave. But I think the key point is that if you do postpone the leave, then you must allow the employee to take a period of leave of the same duration that they have requested within 1 month of the period that they've initially requested. And you would need to give the employee a written notice within 7 days of that initial request that they made, setting out the reasoning for the postponement and the agreed dates on which the leave can be taken. There may be guidance in due course, but as I said, yeah, I think it's likely to include a scenario where there's nobody to cover, and so the business would struggle without that person in their role. Good.
Thanks, Charlotte. Emma, you obviously spoke about the changes to the code of practice on hire and free fire. So what do you need to think about when consulting employees and making changes to their terms and conditions?
Well, helpfully, the code contains a section on what meaningful consultation looks like. So that certainly gives employers a steer. It says that employers should consult with affected employees and or their representatives openly and in good faith and genuinely consider the points put forward. And I think ultimately, the longer that employers consult with employees and other representatives, the more they can demonstrate that actually they have tried to reach agreement, and that is something that the code points out. And you know, it may well be of benefit to employers if they do come up with a mutually beneficial outcome. So it shouldn't just be seen as something that needs to be done just to fulfill the code. I think employers should consider it more widely. And then I think the other point just to mention is that employers should be mindful of any employees who might be absent. So for example, on sick leave or on paternity leave, and yeah, consider them in the context of the consultation.
Thank you, Emma, for that. And so we've gone almost 10 minutes over now, so we were going to wrap up there. I wanted to thank all of you for joining us today. It's been, and thank you for all the questions and participating in the polls. Hopefully you found it interesting and some things to think about there. And again, a reminder that you'll get a feedback form. Please do complete it. We would like to know how you found today's session. And any feedback you have for future webinars, etc. And thank you all for joining today. Thank you, everyone.
Thanks all. Bye-bye.
Bye.